And, do this. This is Talking Foreign Policy, a critical look at Canada's role abroad, and I'm Eve Engler. Today we're talking about a important legal battle. Last week, Barrick Gold, a major Canadian mining company, is brought before Ontario court over killings at its North Mara mine in Tanzania. Barrick is one of the world's biggest gold mining companies, has been for decades. It's been accused of abuses in many places around the world. It's also a powerful force in Canadian foreign policy. Its founder, Peter Munk, is the financier of the Munk School of Global Affairs at the University of Toronto, the Munk debates, and it has been maybe the most powerful of a very powerful Canadian global mining behemoth that has a great deal of impact on Canada's foreign policy. So today, to discuss this case, we have Sara Ghebremusse, who's assistant professor and also the Cassels Chair in Mining Law at Western. First of all, thanks a lot for coming on to Talking Foreign Policy. And can you just give us a little bit of a rundown on this case brought in Ontario court regarding Barrick Gold in Tanzania?
Yeah, absolutely. So this particular hearing was in relation to a lawsuit that was brought against Barrick in November 2022. And so Canadian lawyers at firms that have actually in the past been responsible for a lot of these transnational cases against Canadian mining companies filed a lawsuit on behalf of Tanzanian plaintiffs. And these are individuals who have family members that were shot and killed by mine police that secure the mine in northwest Tanzania, and even those who had directly been harmed by the violence carried out at the mine. And so this particular claim was alleging that Barrick is responsible, directly responsible for the harms that they have faced. And so the hearing was Barrick's effort to actually get the case heard, not in Canada, but in Tanzania. And so Barrick's lawyers were arguing that Tanzania is the more appropriate forum or jurisdiction to hear this case. And it's through something that the common law provides, which is a motion called forum non-conveniens. So it's essentially a defense tactic to argue that actually the jurisdiction in which the claim was brought, so in this case, Canada, is actually not the most appropriate forum to hear this dispute. And in fact, the jurisdiction where the harm occurred, where the plaintiffs are located, where most of the evidence is located, and where there is you know, according to Barrick, a legal system in Tanzania that could actually hear this case fairly, that is more the appropriate forum for this case to proceed. And of course, the plaintiffs are arguing that Barrick is a Canadian company. It is headquartered here in Canada, has an office here in Canada, and the executives, the direction that comes from Barrick parent, even if these executives may be located all over the world, Barrick Parent is located here in Canada. And as a Canadian corporation, this lawsuit should proceed here in Canada. So it was a 3-day hearing before a judge of the Toronto Superior Court of Justice in order to hear whether or not Canada is in fact, and Ontario courts are in fact the better location to hear this claim against Barrick compared to Tanzania.
And so we're talking about some pretty wild amounts of abuses. I believe they're saying that the minimum number of people killed is 77 over the past approximately 17, 18 years, mostly by Barrick financed police forces around the North Mara mine. And I know that there's some estimates say that that 77 is in fact, it's significantly higher than that. So this is some pretty, like the idea one mine would create that much death is a pretty startling thing. But so now, like my understanding was that historically the Canadian courts refused to hear cases brought by Canadian mining companies or other companies operating abroad for their abuses abroad. But then there was some sort of successes in terms of, I guess, changing the court's interpretation of the law. Can you kind of explain to us, how that may have changed and whether you expect that the court will just, say that Tanzania is the domain for where this should happen, and then also maybe a bit about why Tanzania maybe shouldn't be the domain for where this case could be pursued.
hmm Definitely. I mean, it might be helpful for your audience before I do that, Eve, to just sort of explain sort of why North Mara has been such a violent mine. I mean, mining is inherently, a very disruptive and destructive activity. And in the interest for a lot of Canadian companies, in the interest of protecting their property and their mining assets, they often rely either on private security or, in the case of North Mara, actually contracting a police force, the Tanzanian police force, to actually secure the mine. And so the Tanzanian police force are armed. And what has occurred at North Mara, given its proximity to the local population, the mine like literally borders several communities that are, right next to the mine. And that community, the number of those communities have relied on artisanal mining before commercial production began in that area. And so commercial production was disrupting their means of actually making money, being able to support their families. And so a number of individuals have ventured into the mine, into, areas that are where the waste rock is located, and actually try to gather gold from the waste rock in order to sell it. And now, given, you know, the conceptions of private property, of course, that these mining companies have, the view is that these individuals are trespassing. And the way in which the Tanzanian police have opted to respond to that is by using force to physically remove these individuals from the waste rock. If there have been instances where these individuals have tried to bribe police, sometimes that does not go well. And there have also been times when the Tanzanian police have preemptively shot individuals who may just be walking near the mine under this pretense that these are trespassers, that these are criminals. Barrick's lawyers even went so far in the hearing to describe these individuals as part of a criminal syndicate or a gang, to allege that they are, intentionally venturing onto the mine to steal, Barrick's property, Barrick's asset, even though this is waste rock that Barrick has no intention of actually using. And so over the last, let's say about, 10 to 15 years, the Canadian courts have become more open to hearing these type of claims against Canadian mining companies in relation to what I would describe, and I think what is appropriately described as human rights violations that have taken place at their mines, or that their own sort of mining operations through private security have, human rights violations that they have committed. And so the first of this case, I mean, there were a couple of cases in Quebec that were filed in sort of the late 90s into the early 2000s. Those cases did not have much luck in proceeding, not always because of this jurisdictional question, but those cases for other reasons did not proceed. And so the Chalk and Hudbay case, in relation to Hudbay's mine in Guatemala, was the first claim that was brought against Canada. I mean, sorry, against a Canadian mining company here in Canada, where the court said, this case could actually proceed here in a Canadian court. That was followed a few years later by the Garcia and Tahoe litigation that was filed in BC. And the court of first instance, so the BC Supreme Court, initially dismissed that case and said it would be better heard in Guatemala. The BC Court of Appeal reversed that decision. And then sort of the most recent case in what I call sort of this trilogy of common law cases in this area is that case against Nevson Resources, which is called Araya and Nevson, that was also filed in British Columbia. And again, not surprisingly, by the same lawyers that actually brought the Tahoe case. And they're also involved in this case against Barrick, as is one of the co-counsel for the plaintiffs in that Hud Bay case. And in that Nevson case, the Nevson Resources challenged Canada as the appropriate jurisdiction to hear the case, arguing that Eritrea, in that instance, would be more appropriate. The case was at the BC Supreme Court and the BC Court of Appeal. They both found that, in fact, Canadian courts were the more appropriate forum to hear that case because Eritrea, I mean, to this day, does not have a constitution, does not have a functioning judiciary or legal system of any kind. I think the number of lawyers in that country is, I could probably count the number of lawyers on my two hands. And so what Nevson did is actually drop that portion of their defense when the case was appealed to the Supreme Court of Canada. And so what these three cases are telling us is that in certain circumstances, Canadian courts are willing to say that, in fact, yes, Canada would be the more appropriate forum to hear these disputes. But in those three preceding cases, all of them have settled out of court. So we don't know definitively when the case is, if a case like this would be heard on its merits, how a Canadian court would actually decide um, the outcome of the case. So there is the promise and hope of Canadian courts hearing these type of disputes, but we don't know yet if we will get the type of outcomes that will actually hold Canadian mining companies accountable for these human rights violations. And so in this, yeah, go ahead.
I
Oh,
guess
sorry.
one question about like we could have legislation. I understand the U.S. does have legislation on the books that facilitates pursuing their companies in domestic court for abuses abroad. So that's something that the mining justice movement has pushed for. Whereas doing this way is so much work and so many lawyers and to even be able to possibly hear the case. Yeah.
Yeah, of course. Yeah. In the United States, the Alien Tort Statute sort of allowed these private claims against not just American actors, but even foreign actors to be brought in US courts, sort of without having to overcome a lot of these hurdles that we have here in Canada. The US Supreme Court has sort of narrowed and sort of restricted the application of the Alien Tort Statute a bit, which has really deterred sort of further cases being brought and sort of requiring more of a nexus to the United States. So there would be an inability to bring claims against foreign mining companies or other extractive companies in the United States if they don't have a connection to the US. But in Canada, yeah, we do not have legislation that just permits anyone who has faced harm at the hands of a Canadian mining company abroad to bring the case here in Canada. And so what the courts have to rely on is the common law or these like common law traditions that we've inherited from the United Kingdom to decide whether or not Canada is the more appropriate forum. And what that leads to, and sort of which is something that is very central to Barrick's argument in this case, is that it's decided on a case-by-case basis. So in Hud Bay and Tahoe, the courts were using the specific facts of those particular claims, but also facts about the Guatemalan legal system to say, yes, the case should proceed in Canada. Likewise, in the Nevson case, the courts were making particular findings about the legal system in Eritrea. And so what Barrick was arguing in the hearing was that, well, one, Tanzania is not Eritrea. Tanzania, if we're going to compare, because Eritrea has often been called the North Korea of Africa. If Eritrea is North Korea, then Tanzania is South Korea. It has a more advanced legal system. It has a constitution. It has a functioning judiciary. It has lawyers. The plaintiffs would have access to legal counsel. And so they were painting a picture where if we are to look at Tanzania's legal system, it's also a Commonwealth country. So it also inherited a number of the UK's legal tradition in much the same way Canada has. So they were painting a picture where, if we are to compare Tanzania to other jurisdictions in which these type of claims, this forum non-convenience motion was brought and these claims against Canadian mining companies were brought, Tanzania is a much better jurisdiction where these plaintiffs could actually seek and pursue justice. And so they painted this picture where, Tanzania is not so different from Canada, let's say. And so why burden the Canadian legal system with hearing a case where all the evidence is in Tanzania, the plaintiffs are in Tanzania, the actual actors who are responsible for the harm, the Tanzanian police, all located in Tanzania. Why bring this case here in Canada? And so the plaintiffs did have a very difficult argument to make. And what they were essentially arguing, if I could, summarize their arguments for the sake of your audience, they were trying to say that in fact Tanzania's legal system, given how connected, deeply connected the Tanzanian government is to this mine and how influential even Barrick is within Tanzania and how influential the Tanzanian government is over the judiciary, this would not, Tanzania would not be a jurisdiction where these plaintiffs could achieve substantial justice. And they did a very good job, the plaintiffs, of pointing out, specific instances where lawyers have faced intimidation for being critical of the government. They have also illustrated how, access to, 'cause these plaintiffs are not wealthy individuals. They would need access to legal aid, and that is not readily available in Tanzania. And so these plaintiffs should have a right to, to actually bring a claim using the lawyers of their choosing and within the jurisdiction of their choosing. And of course, the plaintiffs were just also arguing Barrick is a Canadian company. How can a company that waves the Canadian flag, when it comes to, after benefiting from Canadian tax laws, financing that's available in Canada, Canadian diplomatic support, when it comes to some measure of actually holding this company accountable for, alleged human rights violations that have taken place at their mine, why can it not then be held accountable within a Canadian court by Canadian legal standards? So that's what this case ultimately boils down to.
And we've seen the Canadian government get heavily involved in Tanzanian affairs on behalf of Barrick Gold. I know in 2016 and 2017, I believe there was quite a big controversy over unpaid royalties, taxes that the Tanzanian government, then President John Magufuli, said that it was into the billions of dollars. And the Canadian government, it was reported that a couple of things. One, that the Canadian government basically threatened to cut off aid to Tanzania, trying to isolate the mining minister that I guess the conflict was with Barrick was principally over. And also the Canadian High Commissioner even organized a meeting between the head of Barrick and the president of Tanzania to discuss the dispute. And then after the meeting, he comes out, Canadian High Commissioner comes out and says that Barrick follows Canadian standards of corporate social responsibility. This isn't a company accused of not paying billions in taxes and has this mine where there's, at that point, I don't know what the exact number was, 50, 65, 70 minimum people have been killed. And so it's quite a clear endorsement, diplomatic endorsement by the Canadian government. So it seems the idea that this is just, has nothing to do with Canada seems hard to argue, at least in the,
Mhm.
political level. But yes, can you tell us a little bit about, I guess, the sort of just Canadian support for Barrick in Tanzania specifically, and I guess even more generally?
Yeah. Well, I don't have in the Tanzanian context, I don't have much more to add than what you said. I mean, it was, yeah, pretty surprising to see, when it became convenient, or not surprising. I mean, it's definitely a tool that Barrick has not been sort of hesitant to tap into. But yeah, as soon as there was a dispute with the Tanzanian government, I mean, actually leveraging Barrick leveraging its relationship and benefiting from the economic, diplomatic supports that are, that that Global Affairs Canada readily provides, that the Minister of International Trade and that office readily provides to actually put pressure on the Tanzanian government and to get an outcome that was beneficial to Barrick. And not too long after that, Barrick actually reached a resolution with the Tanzanian government that led to the Tanzanian government owning a stake in that North Mara mine. And so not only was Barrick sort of leaning heavily on its access to Canadian diplomatic support to help resolve that particular issue, it has then no problem of bringing in the Tanzanian government and sort of, in essence, sort of using the Tanzanian government in some way as a cover to some of the human rights violations that have taken place since that partnership was finalized in 2019, giving Barrick some type of cover to that. So Barrick has as a corporation that waves the Canadian flag, says that it abides by Canadian human rights standards, international human rights standards. It has no problems leveraging those type of relationships, and, having the Canadian government act on its behalf in order to pressure foreign governments to get an outcome that is favorable to that company. And I'm not familiar if Barrick has used similar tactics in other countries, but Barrick is, as you said in your introductory remarks, like the one of the biggest gold mining companies in the world. I think they're the second largest in the world, and they have mines throughout the world, not just in Tanzania or the parts of Africa, but in the Asia Pacific and the Caribbean, in Asia, in the Middle East, here in Canada even. And so presumably, if the Canadian government were to act on behalf of a Canadian corporation, there would be some benefit to Canada of of this corporation. Would there be some type of tax benefit, um, jobs that have been created? But throughout the hearing, Barrick said its presence in Canada is limited to 55 people in this small office in Toronto. So why is the Canadian government upholding this company as, not just as sort of the standard bearer or, you know, a company that does represent Canadian values, but to put Canadian diplomatic resources behind it in its battle with a foreign government when this company says it offers, has very little presence here in Canada? What's the benefit then for Canadians of the Canadian government doing that?
No, that is quite an amazing question. We're going to put all our like leverage behind these abuses of this company, and then
Yeah,
the company comes back and says, "Well, we don't really have anything to do with that country," like which is
yeah,
for the vast majority of Canadians. Now, obviously, that gets, I think, maybe to the bigger question here. That's not just about Barrick, which is that Canada, of course, is this hub of global mining. They listed on Toronto Stock Exchange. They have offices in Toronto. Maybe they don't have anyone working from those offices, but they have offices in Toronto. They sort of and it's almost like the Canadian government is kind of like on autopilot in favor of quote unquote Canadian, how much they are Canadian, mining companies globally. And one element that this sort of mining justice movement has really, worked on over decades now, and the Trudeau government even kind of said they were going to do before they got elected, and even early in their election or after they became elected, to set up an ombudsperson with some degree of actual power to end public Canadian support for Canadian mining companies found to be engaged in abuses abroad. The mining lobby, of course, went hard against this initial proposal from the Trudeau government and ended up with a very watered down kind of position. Can you just maybe talk to us a little bit about this question of like an ombudsperson or some of the proposals floating around out there from the kind of mining justice movement, legal side to kind of restraining the abuses of Canadian mining companies globally?
Yeah, the Canadian Ombudsperson for Responsible Enterprise, as you mentioned, was a result of sort of years of lobbying from the mining justice movement. And when the Trudeau government did commit to creating the Canadian Ombudsperson, it was welcomed as a positive movement and positive outcome sort of in the mining justice movement in Canada. Actually, finally, rather than being sort of a laggard for so many years in the corporate accountability movement, potentially just, I wouldn't say being a leader, but at least catching up to a number of similarly situated countries around the world that have introduced some type of corporate accountability legislation or have more stringent corporate accountability mechanisms. And so initially, the Trudeau government did commit to creating an ombudsperson and an ombuds office that did have some teeth. It was going to be granted investigatory powers, but when the ombudsperson was finally appointed, their mandate was finalized, those investigatory powers were removed. And immediately, the mining justice movement was, you know, heavily criticizing the government for that move. Because without an ombudsperson with teeth, especially investigatory powers to compel participation and to compel evidence from the companies that are subject to complaint, then what power does this ombuds office have? Essentially, what the ombuds office is doing, if it takes on any complaints and conducts their assessment, they're doing so in the absence of the company actually disclosing relevant information and the company actually participating in the process. So in the current or the first ombudsperson, Sherry Meyerhofer, her term ended earlier this year at the end of April. And before her term ended, she published a report which that concluded the first full investigation against a Canadian mining company, against Dynasty Gold, which was accused of complicity in the use of Uyghur forced labor at one of its mines in China. And if you read through the report, like, while, it is um, a finding that, really is a positive step, it was a finding and a conclusion that was made in the absence of that company participating. And so the Ombuds office was making conclusions based on sort of public statements that the company might have made, public statements that some of the company's partners made, um, also based on its own understandings and conclusions that it could reach about the use of forced labor, Uyghur forced labor in that part of China, which it's well reported and well understood. But without being an independent body and without having the investigatory powers that it should have to conduct these type of investigations, I mean, it does leave this ombuds office sort of open to political influence. I'm, to be honest, as what I like to consider myself an objective observer of sort of the office and the space, for the only decision or final report to be issued against a Canadian mining company that wasn't even like directly operating the mine at the time that this complaint was brought forward. It was sort of in this joint partnership with a Chinese company that was actually on the ground running the mine. For that to be the only investigation that the Corps has brought to a conclusion, given, of course, a number of other complaints against Canadian mining companies and even potential future complaints against Canadian mining companies, to me, it really begs the question to what extent there was any type of political motivation behind that. And maybe that's the cynic in me also coming out. But I do think that in the context of Canada having diplomatic relations with China that are largely centered on human rights, and critiquing the Chinese government for human rights violations of of Uyghurs, then it seems like the Canadian government is more than happy to support an ombuds office that, could critique a country and a like China and a mining company, even though it's a Canadian mining company that was operating there, but I doubt we would ever see from this office a similar outcome against a company like Barrick or another similarly situated Canadian mining company that is either operating in countries where Canada wants to maintain its diplomatic relations, or good diplomatic relations in those countries, or with companies that again are quite influential and have close ties to the Canadian government. And so the mining justice movement is still highly critical of what the Canadian ombudsperson, can offer. And through our discussion, it was very clear that pursuing a case against a Canadian mining company for human rights violations it's involved in abroad, it's very difficult to do that through the courts. So the ombudsperson is meant to be a grievance mechanism, a non-judicial grievance mechanism that should be more accessible than the Canadian courts. But if lacks independence, if it lacks the power to compel um, evidence and participation, even if it lacks the power to actually issue binding remedies, like the case against Dynasty Gold, the remedies that the core um, issued, Dynasty Gold is in a position where it could just say, you know what, thanks, but we don't have to do anything in response to these, what are called recommendations. And so without those sort of key components of what's expected from a grievance mechanism, or a body that is meant to provide some type of remedy and redress for victims, then this core is really just, yeah, it's a toothless entity. And right now, I'm sure you're aware the Canadian Ombudsperson's office is undergoing a review that the Canadian government committed to doing in response to a standing committee. I don't know the blank on the full title because it's such long, but a standing committee of Parliament issued a recommendation to the government of Canada last year to conduct a review of the core. And so that's currently ongoing. And I think, again, the mining justice movement is going to be making the same recommendations that it has been for several years. But it does not look like the current Canadian government, and I suspect any future Canadian government, whether the Liberals stay in power or if the Conservatives are elected, which looks like to be the case, I don't think the core will actually be empowered to really fulfill its mandate in the way that adheres to international standards.
It's a pretty remarkable the power of the mining sector that this obviously shows, despite decades of campaigning, incredible number of abuses abroad, and a government committing to doing it, beginning the process of doing it, and then the mining industry just able to sort of squash that. Thanks a lot for this discussion. Again, Sara Ghebremusse, who is the professor at Western Law and the Cassels Chair in Mining Law at Western. Thanks a lot for coming on Talking Foreign Policy.
You're very welcome. It was my pleasure.